Okay, let's talk about the law on rape and consent here in the UK. Now, I know it can seem incredibly complex and, honestly, pretty confusing, but the good news is it all comes down to one key piece of law, the Sexual Offences Act of 2003. So, in this explainer, we're going to break that act down, piece by piece, to make it as clear as we possibly can. Let's dive in. Here's the roadmap for how we're going to do this. First, we'll look at the law's precise definition of rape. Then we'll unpack a really key legal idea, the difference between the physical act and the mental state behind it. From there, we'll get into the absolute core of it all, the meaning of consent. Then we'll look at how the courts handle situations where consent is unclear. And finally, we'll wrap it all up with the key things you really need to remember. All right, let's start at the very beginning with Section 1 of the Act. You have to think of this as the foundation. It's the cornerstone that lays out the official three-part legal definition of the crime of rape. Everything else that we're going to talk about builds on this right here. So look at how specific the law is. For the crime of rape to be proven, the prosecution has to prove three things. Not one, not two, but all three. First, that intentional penetration happened. Second, that the other person, B, did not consent. And third, and this is so important, it's all about the accused state of mind. That person A did not have a reasonable belief that B was consenting. Now, to really get your head around any crime, lawyers do something very clever. They split it into two different parts. You have the physical bit, what actually happened, which they call the actus reus, or the guilty act. And then you have the mental bit, what was going on in the person's head, the mens rea, or the guilty mind. It's basically the difference between what someone did and what they thought. So, let's take that act versus mind idea and map it directly onto the definition of rape we just looked at. This is a super helpful way to see how the law separates a person's physical actions from what they were actually thinking or believing at the time. And here is how it breaks down. The actus reus, the physical side of things, has two parts. There was penetration, and the complainant did not consent. Simple as that. The mens rea, the mental side, also has two parts. The penetration was intentional, and the accused did not have a reasonable belief in consent. And remember, the prosecution has to prove every single one of these elements. So, just to hammer this home, the actus reus is all about the physical facts of the case. What literally happened? Did this specific act of penetration occur? Yes or no? Was there consent from the other person? Yes or no? It's all about the observable reality, totally separate from anyone's private thoughts or intentions. Okay, now we are getting to the absolute heart of this law, the part that's so often debated and misunderstood, consent. So what does the law actually say consent is? You know, before this act in 2003, there was no single, clear, legal definition of consent. This was a game changer. Section 74 says consent is an active agreement, and for that agreement to be real, three things have to be true. The person agrees by choice, they have the freedom to make that choice, and they have the mental and physical capacity to make it. Choice, freedom, and capacity. And through various cases, the courts have really helped clarify what that freedom to choose actually means in the real world. 2 points here are absolutely vital to understand. First, just going along with something because you're scared or pressured or frozen, that is submission. It is not consent. And second, and this is a massive misconception, rape does not require a violent struggle. The crime is about the absence of consent, not the presence of force. Okay, so we've defined the crime and we've defined consent, but how does a court deal with the incredibly tough job of figuring out if consent was actually there or not? Well, the Act gives them two very powerful tools to help them, and they're called presumptions. I mean, that's the key question, isn't it? When it often comes down to one person's word against another's, you need some kind of framework. And that's exactly what these presumptions are for. They're divided into two types, and they work in slightly different ways. First up, we've got Section 76. This deals with what are called conclusive presumptions. And that word conclusive is key. It means exactly what it sounds like. If the prosecution can prove one of these specific things happened, then the law concludes consent was absent. End of story. The point can't even be argued. There are only two of these, and they're very, very specific. The first is if the defendant intentionally deceived the other person about the nature or purpose of the act. Think of someone pretending to be a doctor carrying out a medical exam. The second is impersonating someone the complainant knows personally. If either of those things is proven, the law says there was no consent and there couldn't have been a reasonable belief in consent. It's conclusive. Game over on that issue.
All right, the second tool is in Section 75, and this is for evidential presumptions. Now, unlike those conclusive ones, these aren't an automatic knockout blow, but they do have a huge impact by shifting the legal playing field, and they cover a wider range of situations. This section basically lists a series of red flag scenarios. So things like violence being used or threatened, a person being asleep or unconscious, or maybe they've been drugged. If the prosecution can prove that any of these circumstances existed when the act took place, the law then automatically presumes that there was no consent.
So what does this actually do in a trial? Well, it flips the script. It doesn't mean automatic guilt. What it means is the legal burden shifts. So once the prosecution proves one of those situations happened, let's say the person was asleep, a switch gets flipped. The law now presumes there was no consent and no reasonable belief. So the ball is now in the defendant's court. It's up to them to bring enough evidence to challenge that presumption and make a case that there actually was consent or at least a reasonable belief in it.
Whew, okay, we have covered a lot of pretty dense legal ground there. So let's take a step back and just pull together the absolute essential points from the Sexual Offences Act that you need to know.
Honestly, these specific sections we've walked through, they are the engine of this law. You really can't understand how these cases are handled without getting a grip on how these individual parts all fit together to define the crime, define consent, and guide the courts. So if you remember anything, remember these 4 pillars. Section 1 gives us that 3-part definition of the crime. Section 74 tells us what consent actually is: choice, freedom, capacity. Section 76 gives us those 2 game-over conclusive presumptions. And Section 75 gives us that list of red flags, like violence or unconsciousness, that shift the burden of proof. That's the whole legal framework in a nutshell. And all of that brings us to one final huge thought. After all this complex legal machinery, so much of it boils down to just 2 words from Section 1: reasonable belief. The law doesn't define what's reasonable. It's left for a jury to decide. So what do you think that means? What steps, what words, what actions would a court look at to decide if someone's belief in consent was actually reasonable? That's the central question, right at the very heart of this law.